What is the antebellum period? The antebellum period is designated as the era before the start of the Civil War, and it extends and bypasses the War of 1812. It also thought of to represent the time of the adoption of the Constitution in 1789 to the very end of the Civil War in 1865. During these years, leadership from the South had transitioned from Virginia to South Carolina due to the fact that cotton was a primary resource and product, and slaves were seen as substantial to the betterment of the future. North Carolina's African American population was split in half, one half being enslaved blacks and the other being free blacks. Before the start of the Civil War, North Carolina's people of color, that is, American Indians and blacks, blossomed. On the other hand, in the South, only Maryland and Virginia acknowledged having more free people of color. Many free blacks were skilled artisans. Others hired themselves as laborers, domestics, and they were also preachers. Some even owned slaves themselves and purchased relatives in intentions to free them. Of the two split parts of free and enslaved blacks came another section, fugitive slaves, also known as runaway slaves. You see, in North Carolina, the slaves did not sit well with willingly submitting to enforced servitude, and due to this, the resistance and rebellion occurred. Many fled through the Underground Railroad, and if the slave was caught, brutal chastisement was put in effect. Slaves had been trying to rebel and revolt before, during, and after the antebellum period. As far back as when they were in ships, some even jumped off of the ship in the ocean to avoid capture. A timeline of the events that occurred before the antebellum period, transitioning into and out of it, is the following. In 1705, slaves were beginning to be described as real estate. Runaways were allowed to be murdered, and slaves were allowed to be submitted in wills. In 1712, a slave revolt happens in New York. 9 whites are killed, and 21 slaves were murdered. In 1730, slave conspiracy is discovered in Virginia. In 1734, a rebellion plot is discovered in Pennsylvania. In 1739, a slave rebellion happens in Stillnose, South Carolina. The revolt was led by a slave by the name of Cato, who used his understanding of drums to communicate with other Africans, assembling an army of 100. Once he stops to celebrate, he is captured and killed along with 14 slaves and 7 whites. In 1741, a sequence of suspicious fires and slave conspiracies led to general hysteria. 31 slaves along with 5 whites were murdered. In 1773, Massachusetts slaves petitioned for slavery. In 1775, an American Revolution began. Anthony Benezet is the founder of the first abolitionist society. Lord Dunmore grants any blacks who fight for the ground, freedom, and many blacks free from plantations and help the British. In 1777, Vermont is the first state to abolish slavery. In 1784, Congress defeats Thomas Jefferson's proposal to forbid slavery in the new territories after the 1800s. In 1787, the Northwest Ordinance combines with state-initiated emancipation laws to create a free North. In 1791, a Haitian slave rebellion leads to plantations, crops, and buildings being burned to dust. In 1793, the Fugitive Slave Act of the United States outlaws any efforts to obstruct the efforts of runaway slaves. In 1800, Gabriel Presser plans a slave rebellion and is betrayed. Nat Turner and John Brown are born. In 1811, Louisiana slaves revolt. One is the largest slave revolt in the United States history and is led by Charles Deslandes. In 1817, Frederick Douglass, a fugitive slave, was born. In 1820, Harriet Tubman, a fugitive slave, was born. In 1822, Denmark Vesey plans a rebellion and is betrayed by a house slave. In 1828, there was a race riot in Ohio. In 1831, Nat Turner instigates a slave revolt that kills many whites but ends up unsuccessful. In 1836, the gag rules passed prohibiting all bills or laws anti-slavery related. In 1837, Joseph Taper ran away. In 1838, Frederick Douglass escaped from slavery. In 1839, Joseph Simcoe leads an Amistad slave rebellion, but the ship is captured. In 1840, a slave revolt on a slave trader Creole is conducted. In 1842, Harriet Jacobs makes her escape to the north. Leigh versus Pennsylvania was decided. In 1845, 75 slaves armed themselves and marched to Pennsylvania. Many are killed and 31 are captured. In 1848, Henry Brown's family were sold and shipped to another state. The Crafts both escaped, Ellen acting as a white man and William acting as her servant due to differences in skin color. In 1849, Henry Brown plans escape. Harriet Tubman escapes. In 1851, a fugitive slave is rescued from conviction. In 1854, Kansas-Nebraska Act is signed, and Congress allows the two new territories to change whether or not they will allow slavery. In 1857, Supreme Court decides that blacks aren't citizens, not allowing them rights. In 1858, John Brown raids Harper's Ferry to arm slaves with weapons to use during slave rebellions. In 1860, Abraham Lincoln is elected. In 1861, the Civil War begins, claiming 623,000 lives. In 1865, slavery was abolished, and that's the end of the Civil War. Personal liberty laws. Personal liberty laws protected runaway slaves from being returned to their masters. Here are the personal liberty laws read word by word. You can pause the video at any time to read/interpret them. In 1840, New York passed an act securing a trial by jury to persons accused of being fugitive slaves. Pennsylvania and Rhode Island passed similar laws. The case of Prigg versus Pennsylvania was decided in 1842. A year later, 1843, Massachusetts and Vermont passed laws prohibiting state officers from performing the duties exacted of them by the first fugitive slave law, and forbidding the use of the jails of the state for the detention of fugitives. The Fugitive Slave Law of 1850 was passed, which avoided all employment of state officers and necessitated a change in the personal liberty laws. New laws were passed by Vermont, Rhode Island, and Connecticut in 1854. A year later, Maine, Massachusetts, and Michigan followed. 3 years later, laws were passed by Wisconsin and Kansas in 1858, by Ohio in 1859, and by Pennsylvania in 1860. These laws generally prohibited the use of the state's jails for imprisoning fugitives, allowing state officers under various names to act as a counsel for persons alleged to be fugitives. Secured to all such persons the benefits of requiring the believed fugitive to be brought before a judge and trial by jury. Required the identity of the fugitive to be proved by a couple of witnesses. It prohibited state judges and officers to issue writs or give any assistance to the claimed fugitive, and imposed a heavy fine and imprisonment for the crime of forcibly seizing or representing as a slave any free person with intent to reduce him to slavery. New Hampshire, York, Jersey, and Indiana, and Illinois, and Iowa, Minnesota, California, and Oregon passed no full personal liberty laws. But there were only two of those states, New Jersey and California, which gave any official sanction or assistance to rendition of fugitive slaves. However, 3 of them, Indiana, Illinois, and Oregon, did so indirectly by prohibiting the entrance within their borders of Negroes, either slave or free. If any person or persons shall, from and after the passing of this act, by force and violence, take and carry away, or cause to be taken or carried away, and shall, by fraud or false pretense, seduce or cause to be seduced, or shall attempt so to take, carry away, or seduce any Negro or mulatto from any part or parts of this Commonwealth to any other place or places whatsoever out of this Commonwealth, with a design and intention of selling and disposing of, or causing to be sold, or of keeping and detaining, or of causing to be kept and detained such Negro or mulatto as a slave or servant for life, or for any other term whatsoever. Every such person or persons, his or their aiders or abettors, shall, on conviction thereof in any court of this Commonwealth, having competent jurisdiction, be deemed guilty of a felony, and shall forfeit and pay at the discretion of the court, passing a sentence of sum not less than $500 nor more than $1,000. 1/2 whereof shall be paid to this person or persons who shall prosecute for the same, and the other half to this Commonwealth, and moreover shall be sentenced to undergo a servitude for any term or terms not less than 7 years nor exceeding 21 years, and shall be confined and kept to hard labor, fed and clothed in a manner as is directed by the penal laws of this Commonwealth for persons convicted of robbery. If any person or persons shall hereafter knowingly sell, transfer, assign, or shall knowingly purchase, take, or transfer an assignment of any Negro or mulatto for the purpose of fraudulently removing, exporting, or carrying said Negro or mulatto out of the state with the design or intent by fraud or false pretense of making him or her a slave or servant for life or for any term whatsoever, every person so offended shall be deemed guilty of a felony, and on conviction thereof shall forfeit and pay a fine of not less than $500, nor more than $2,000, 1/2 whereof shall be paid to the persons or persons person who shall prosecute for the same, and the other half to the Commonwealth. And moreover shall be sentenced at the discretion of the court to undergo a servitude for any term or time not less than 7 years, nor exceeding 21 years, and shall be confined, kept to hard labor, fed, and clothed in the same manner as directed by the penal laws of the Commonwealth for persons convicted of robbery. When a person held to labor or servitude in any of the United States or in either of the territories thereof under the laws thereof shall escape into this Commonwealth, the person to whom such labor or services due, his or her duly authorized agent or attorney constituted in writing, is hereby authorized to apply to any judge, justice of the peace, or alderman who on such application supported by the oath or affirmation of such claimant or authorized agent or attorney as aforesaid, that the said fugitive hath escaped from his or her service or from the service of the persons for whom he is duly constituted agent or attorney, shall issue his warrant under his hand and seal, and directed to the sheriff or any constable of the proper city or county, authorizing and empowering said sheriff or constable to arrest and seize the said fugitive who shall be named in said warrant, and to bring said fugitive before a judge of the proper county. No judge, justice of the peace, or alderman shall issue a warrant on the application of any agent or attorney as provided in the said third section, unless the said agent or attorney shall, in addition to his own oath or affirmation, produce the affidavit of the claimant of the fugitive taken before and certified by a justice of the peace or other magistrate authorized to administer oaths in the state or territory in which such a claimant shall reside, and accompanied by the certificate of the authority of such justice or other magistrate to administer oaths, signed by the clerk or prothonotary, and authenticated by the seal of a court of record in such state or territory, which affidavit shall state the said claimant's title to the service of such fugitive, and also the name, age, and description of the person of such fugitive. It shall be the duty of any judge, justice of the peace, or alderman, when he grants or issues any warrant under the provisions of the third section of this act, to make a fair record on his docket of the same, in which he shall enter the name and place of residence of the person on whose oath or affirmation the said warrant may be granted. And also, if an affidavit shall have been produced under the provisions of the fourth section of this act, the name and place of residence of the person making such affidavit, and the age and description of the person of the alleged fugitive contained in such affidavit, and shall, within 10 days thereafter, file a certified copy thereof in the office of the clerk of the Court of General Quarter Sessions of the Peace, or mayor's court of the proper city or county, and any judge, justice of the peace, or alderman who should refuse or neglect to comply with the provisions of this section shall be deemed guilty of a misdemeanor in office, and shall, on conviction thereof, be sentenced to pay, at the discretion of the court, any sum not exceeding $1,000, one half to the party prosecuted for the same, and the other half to the Commonwealth. And any sheriff or constable receiving and executing the said warrant shall, without unnecessary delay, carry the person arrested before the judge, according to the exigency of the warrant. And any sheriff or constable who shall refuse or willingly neglect to do so be sentenced to pay, at the discretion of the court, any sum not exceeding $500, one half to the party prosecuted for the same, and other half to the Commonwealth, or shall also be sentenced to imprisonment at hard labor for a time not exceeding 6 months, or both. The said fugitive from labor or service, when so arrested, shall be brought before a judge as aforesaid, and upon proof to the satisfaction of such judge that the person so seized or arrested doth, under the laws of the state of authority from which she or he fled from service or labor, to the person claiming him or her, it shall be the duty of such judge to give a certificate thereof to such claimant, his or her duly authorized agent or attorney, which shall be sufficient warrant for removing the said fugitive to the state or territory from which she or he fled, provided that the oath of the owner or owners or other person interested shall in no case be received in evidence before the judge on the hearing of the case. When a fugitive shall be brought before the judge, agreeably to the provisions of this act, and either party allege and prove to the satisfaction of the said judge that he or she is not prepared for trial and have testimony material to the matter in controversy that can be obtained in a reasonable time, it shall and may be lawful, unless security satisfactory to the said judge be given for the appearance of the said fugitive on a day certain to commit the said fugitive to the common jail for safekeeping, there to be detained at the expense of the owner, agent, or attorney for such time as the judge shall think reasonable and just, and to a day certain when the said fugitive shall be brought before him by habeas corpus in the courthouse of the proper county or in term time at the chamber of the said judge for final hearing and adjudication, provided that at the adjournment of the hearing be requested by the claimant, his agent or attorney, such adjournment shall not be granted unless the said claimant, his agent or attorney shall give security satisfactory to the judge to appear and prosecute his claim on the day to which the hearing shall be adjourned, provided that on this hearing last mentioned, the judge committing the said fugitive or taking the security as aforesaid should be absent, sick, or otherwise unable to attend. It shall be the duty of either of the other judges on notice given to attend to the said hearing and to decide thereon. The officer which may or shall be employed in the execution of the duties of this act shall be allowed the same fees for service of process that sharers within this Commonwealth are now allowed for serving process in criminal cases, and $2.50 per day for each and every day necessarily spent in performing the duties enjoined on them by this act to be paid by the owner, agent, or attorney immediately on the performance of the duties aforesaid. No alderman or justice of the peace of this Commonwealth shall have jurisdiction or take cognizance of this case of any fugitive from labor from any of the United States or territories under a certain act of Congress passed on the 10th day of February 1793, entitled An Act Representing Fugitives from Justice, and persons escaping from the service of their masters, nor shall any alderman or justice of this peace of this Commonwealth issue or grant any certificate or warrant of removal of any such fugitive from labor as aforesaid, except in a manner and to the effect provided in the third section of this act. Upon the application, affidavit, or testimony of any person or persons whatsoever under the said act of Congress, or under any other law, authority, or act of the Congress of the United States, and if any alderman or justice of the peace of this Commonwealth shall, contrary to the provision of this act, take cognizance or jurisdiction of the case of any such fugitive as aforesaid, except in a manner hereinbefore provided, or shall grant or issue any certificate or warrant or removal as aforesaid, then in either case he shall be deemed guilty of a misdemeanor in office, and shall on conviction thereof be sentenced to pay at the discretion of the court any sum not less than $500 nor exceeding $1,000, one half thereof to the party prosecute for the same, and the other half to the use of the Commonwealth. It shall be the duty of the judge or recorder of any court or record in this Commonwealth when he grants or issues any certificates or warrant or removal of any Negro or mulatto claimed to be a fugitive from labor to the state or territory from which he or she fled, in pursuance of an act of Congress passed this 12th day of February 1793, entitled An Act Respecting Fugitives from Justice and Persons Escaping from the Service of their Masters, and of this act to make a fair record of the same, in which he shall enter the name, age, sex, and general description of the person of the Negro or mulatto for whom he shall grant such certificate or warrant of removal, together with the evidence and the name of the places of residence of the witnesses and the party claiming such Negro or mulatto, and shall within 10 days thereafter file a certified copy thereof in the office of the clerk of the Court of General Quarter Sessions at the Peace or Mayor's Court of the city or county in which he may reside. Nothing in this act contained shall be construed as a repeal, or alteration of any part of an act or assembly passed the first day of March 1780, entitled An Act for the Gradual Abolition of Slavery, except the 11th section of said act, which is hereby repealed and supplied, nor of any other part of an act assembly passed on the 20th day of March 1788, entitled An Act to Explain and Amend an Act for the Gradual Abolition of Slavery, except the 7th section of this last mentioned act, which is hereby supplied and repealed. Fugitive Slave Law of 1850. The Fugitive Slave Law of 1850 was a part of the Compromise of 1850. This law enabled the United States to aid slave owners in recapturing runaway slaves. Due to the United States Constitution, slave masters were able to capture slaves who ran away to free states. Anyone caught hiding fugitive slaves faced penalties and punishments. Since I've touched on the antebellum period, the Fugitive Slave Law of 1850, and personal liberty laws, now it's time to discuss what this video is about: fugitive/runaway slaves and the laws that tag along with them. Here are a few fugitive slaves. We've all heard about Harriet Tubman, slave born but abolitionist bound. Araminta Ross, whom we know as Harriet Tubman, was born in Maryland of 1820, escaped to freedom in 1849 to become a conductor of the Underground Railroad. Harriet helped lead many fugitive runaways slaves away from subjugation, excluding the fact that she's a runaway slave herself. We all heard of the phrase, living in a shoebox. Try making your temporary home a crate. Many of us wouldn't be able to do such, but Henry Box Brown, born in Virginia, was able to. You see, his family, wife, and children were sold and shipped away to another state in 1848, and he wanted to escape bondage under any condition. Thus, with the help of a white shopkeeper and a free black, he conducted an absurd plan. He decided to ship himself in 1849 from Richmond, Virginia to Philadelphia, Pennsylvania, in a wooden crate labeled dry goods, via wagon, steamboat, and railroad to the home of an abolitionist by the name of James Miller McKim. Another fugitive slave around the antebellum area that we all know is Frederick Douglass. Many of us know of Douglass but don't know of his actual story. Before his second escape attempt, he tried to escape slavery 2 years before but was betrayed by another slave. Once he was caught, he was jailed, sent to Baltimore by his master, and hired out to work in the city shipyards. On September 3rd, 1838, 20-year-old Frederick Douglass, then known by his birth name Frederick Augustus Washington Bailey, decided to try again. He felt as though if his escape attempt didn't work this time, he'd remain a slave forever. Luckily, everything went as planned. Douglass disguised himself as a free black sailor in a suit provided by Anna Murray, his future wife. He wore a red shirt, a loosely knotted black cravat around his neck, and a sailor's hat on his head. In his pocket, he kept a sailor protection pass given to him by an accomplice. He looked nothing like the man in the documents, but luckily the conductor quickly glimpsed at the papers, detecting no suspicion. He also went through other life-threatening events, such as spotting one of his old ship captains. Luckily, he made it to New York and hid in the home of an anti-slavery activist. Douglass was considered a fugitive slave until 1846, but he was able to purchase his freedom from his former master. He also had connections and ties to the Civil War, you see. He persuaded President Lincoln to allow enslaved blacks to fight for their freedom. I've told you about Harriet Tubman. Now here's the story of Harriet Jacobs. Jacobs, born a slave in North Carolina, was tired of her cruel master making sexual advances with her. In 1835, Jacobs left the plantation and hid in the homes of her friends. She knew that making it to the North would be a daring trip and stayed in her grandmother's attic for 7 years. The room was rat-infested, tiny, and only 9 feet long and 7 feet wide. She finally made her escape to the North in 1842 with the aid of a friend helping to secure her space on a boat bound for Philadelphia. She then made her way to New York and rekindled with family members. William and Ellen Craft. They were married in 1846, but were then separated and held captured by 2 different masters. The separation wasn't very well with them, and they decided to flee through the South, making their way to Philadelphia. Ellen, a light-skinned slave, cut her hair short and dressed in men's apparel, wrapping wraps around her head to resemble an injured white man, and William played the role as her manservant. In 1848, the Crafts put on their outfits and placed their acts in effect during their journey to the North. Ellen found herself sitting next to a close friend of her master, but due to her costume, she wasn't recognized. They spent the next few days traveling by train and associating with upper-class whites to maintain their cover. Due to the fact that Ellen could not read or write, she wrapped her arm up and avoided signing documents. A Charleston steaming clerk refused to sell them tickets due to this, but by their luck, the captain of the previous ship signed the tickets for them, and they made it to Philadelphia and were sheltered by abolitionists. Joseph Taper, a fugitive slave who ran away in 1837 with his wife and children to Pennsylvania. They then left and went to Canada when a slave hunter was said to be in the neighborhood. Taper wrote the following to his white acquaintance in Virginia about his experience. Dear Sir, I now take the opportunity to inform you that I am in the land of liberty and good health. I have paid $50 rent this year. Next year I expect to build. The Queen of England has granted 50 acres of land to every colored man who will accept of the gift and become an actual settler. Also, a yoke of oxen and plow for every 2 families. This is a very great encouragement to those who would come here for the liberty which God has designed for them. Since I have been in the Queen's dominions, I have been well contented. Yes, well contented for sure. Man is as God intended he should be. That is, all are born free and equal. This is a wholesome law, not like the southern laws which puts man's made in the image of God on level with brutes. Oh, what would become of the people, and where will they stand in the day of judgment? With that, the 5th verse of the 3rd chapter of Malachi were written as with the bar of iron and the point of a diamond upon every oppressor's heart, and they might repent of this evil and let the oppressed go free. We have good schools and all the colored population supplied with schools. My boy Edward will be 6 next year's January, is now reading, and I intend keeping him at school until he becomes a good scholar. I have enjoyed more pleasure within 1 month here than in all my life in the land of bondage. My wife and myself are sitting by a good, comfortable fire, happy, knowing that there are none to molest or make us afraid. God save Queen Victoria. The Lord bless her in this life and crown her with glory in the world to come. This is my prayer. Yours with much respect, most opt Joseph Taper. 2 significant quotes that have to do with this project are the following. It is known over the state and out of the state, over the line in the north and over the line in the south, I don't respect this law. I don't fear it, I won't obey it. It outlaws me and I outlaw it, and the men who attempt to enforce it on me. I place the governmental officials on the ground that they place me. I will not live a slave, and if force is employed to re-enslave me, I shall make preparations to meet the crisis and becomes a man. If you will stand by me, and I believe you will do it, for your freedom and honor are involved as well as mine. It requires no microscope to see that. I say, if you will stand with us in this resistance to the measure, you will be the saviors of your country. Jermaine Wesley Logan, a fugitive slave on the fugitive slave law. As you can tell from this quote, Wesley, a prior slave, is strongly against the Fugitive Slave Act due to the fact that he is a fugitive slave. He's not going to allow it to enforce on him. He's not going to allow it to enforce it. He's not going to allow the government to enforce it on him, and he's asking his community for help and fighting against it. I have never hesitated to say, and I do not now hesitate to say, that I think under the Constitution of the United States, the people of the southern states are entitled to a congressional fugitive slave law. Abraham Lincoln on the fugitive slave law. As you can tell by the following quote, Lincoln felt though the fugitive slave law is reasonable and justified and believes the United States should be able to assist slave masters in capturing runaway slaves. A summary of the following project is: the following project touches on aspects of the lives of fugitive slaves during the antebellum era. A timeline is included detailing events from 1705 to 1865, starting with slaves being described as estate and ending off with the ending of the Civil War. The timeline talks about revolts, rebellions, conspiracies, and slaves fighting for their freedom. It talks about the birth of certain fugitive slaves along with when they escaped. It touches on certain laws being passed in the beginning and end of the Civil War. It also describes what the fugitive slaves went through and how they got out of it. This project describes the antebellum period as a whole, informing the reader/listener on what the antebellum period is. When it started and ended, it even touches on way before the antebellum period, which would be considered capture. Capture is the time period where slaves were taken from certain areas and put on boats to season. Many of the fugitive slaves talked about above are kin and descend from the first slaves that survived capture and seasoning. Not all the slaves survived decades before the antebellum era due to epidemics, suicide, and murder. Fugitive slaves talked about in this presentation are the Crafts, Joseph Taper, Harriet Tubman, Harriet Jacobs, Frederick Douglass, and Henry Box Brown. All were born as slaves but didn't allow that to be their destiny. They escaped, some by train, some by the Underground Railroad, and one even in a crate. They were determined and motivated to be free. There were many more fugitive slaves, some who died during rebellion, others that weren't talked about. There are also abolitionists that helped these slaves and aided them in running away. John Brown, a white abolitionist that we talked about in class, held 2 rebellions. One was successful and sadly the other wasn't. He and a few of his sons were murdered for what they believed in, along with their black and white allies. During this time period, Brown needed help from other abolitionists, and some did, such as the ones who donated to him anonymously. All abolitionists aren't white, as you can convey from this project. Even blacks can be abolitionists. This project also indicates how certain measures were made to protect runaway slaves. These measures were the personal liberty laws. Personal liberty laws protected runaway slaves and made sure that they wouldn't be taken and returned to their master. A present-day example of this can be in Central, to be exact. We stand with immigrants and keep their information secure so that ICE cannot take them and deport them. The Fugitive Slave Laws was basically vice versa of the Personal Liberty Laws. The Fugitive Slave Law of 1850 favored slave owners and allowed the United States to assist in recapturing slaves and returning them to their plantations.